My name is Pat Iyer. I'm the president of MedLeague, a legal nurse consulting company I started in 1989. I know you're here to find out more about medical records. I have reviewed thousands of medical charts in the 26 years I've been reading them for litigation. Recently, I asked attorneys what their biggest challenges were with medical records. They were attending a program that I taught for medical records for the New Jersey Institute of Continuing Legal Education. Here's what they had to say. There is lack of uniformity in charting systems. An attorney who looks at records from many facilities will quickly realize there is no uniformity among facilities and providers. Handwritten medical records are historically designed with little reference to standardization and are periodically redesigned when accreditation standards mandate certain changes. For example, the requirement to determine if a patient might have been abused prior to a hospital admission led to adding this to many medical record forms, such as emergency department records and nursing admission records. Electronic medical record software designers struggle with the same issue. This is a challenge that affects records in lots of settings. One of the solutions to this is to impose standards for handwritten and electronic medical records. This solution challenges the American cultural perspective that encourages us to be individualistic, to do our own thing, at the expense of uniformity. Another solution, which is more realistic, is to carefully look at the way medical records are constructed to assemble a sense of the pattern that the facility uses. For example, we have learned these patterns by organizing medical records for cases that we review in-house or send to our expert witnesses. Get more tips like this by visiting medleague.com. While you're there, get our free ebooks, 275 Tips About Medical Records, a guide for attorneys, and the ABCs of medical abbreviations.